K, Element and others.
Yes, Mr. Reid.
My lord and my ladies. I appear on behalf of the appellant in this matter, Tesco. With me, my learned friends, Mr. Matthew Purchase, King's Counsel, and Miss Louise Chugley. On behalf of the respondents to this appeal, there are, and I group them by their representative solicitors, on behalf of the Harcus claimants, Mr. Keith Bryant, King's Counsel, and with him, Mr. Stephen Butler. And on behalf of the Lee Day claimants, Mr. Sean Jones, King's Counsel, and with him, Mr. Andrew Blake, although I think on paper, Miss Rachel Barrett appears before you in submissions. There is, I fear, a substantial amount of paper in relation to these appeals. I don't know, before I embark upon outlining my approach and the skeleton, for the purposes of my own assistance, I don't know whether you're proposing to deal with to access materials in the paper form or the electronic form.
I prefer using the hard copy, although I do have the soft copy with me.
Thank you. I'm sorry, it may mean, I'm afraid, moving between bits and parts of the bundles. Formally, this is a hearing of two appeals. An appeal against the judgment and order of His Honour Judge Taylor of the 5th of February, 2025, which the parties have described as being the scope appeal.
Yes.
Just by way of note, that was listed for hearing last year and coincided with the handing down, although at that point in time embargoed, of the judgment which is the subject of the second appeal, yes, which is the appeal against the judgment of Mrs. Justice Stacey.
Can I ask you a question before we go any further?
Yes.
Are we having a transcript?
Yes, we are having a transcript.
Yes. It is helpful when the parties have arranged for a transcript if the court is told at the outset, because it affects the detail of the notes we make. And I'm assuming that the parties will arrange for a copy of the transcript to be provided to the members of the court.
So the answer is yes, there is, and the parties will of course arrange for you to have access to the transcript.
Thank you very much. Yes, sorry to have interrupted.
No, fine. So so that appeal is the appeal against, second appeal is the appeal against the judgment of Mrs. Justice Stacey of the 31st of July of last year, which we've described as being the substantive appeal. Underneath that are a number of decisions of the Employment Tribunal sitting at Watford, engaged in stage 2 of a equal value, equal pay claim. And just by way of note, for these purposes of clarity, there are 5 at present, although not all of the subject of this appeal, decisions which are the focus of the decision. The first is a judgment referred to by the parties as the first decision of the Employment Tribunal, which is the 1st of July 2023. That was followed by a case management order, which was the 26th of July 2023. That led to the first appeal that Sainsbury's lodged, and I think originally appealed by other parties.
You said Sainsbury's.
Too many shops. I mean Tesco's. Tesco's lodged. It was then followed by a substantive judgment of the Employment Tribunal on the 4th of July 2024. That is the subject of the second appeal that Tesco's brought to the ET. That judgment contemplated the ET, contemplated by the ET, the parties making applications for reconsideration, and the parties all did, and that led to a judgment described as the first reconsideration judgment, or sometimes the third judgment, which is the 30th of May of 2025. That led to further applications for reconsideration by the Employment Tribunal, and that led to a second reconsideration judgment by the Employment Tribunal dated the 28th of July of 2025. So underneath this process, underneath this set of appeals at the level of the ET, there are effectively 5 decisions. It's also worth noting that that second reconsideration judgment was the subject of further applications for reconsideration by the parties, and the tribunal's disposal of those applications led to appeals by all parties to the EAT, all of which were upheld. I should say they're effectively procedural appeals about the way that the tribunal was dealing with those applications, all of which were recently upheld by His Honour Judge Taylor on the 26th of February. And have been remitted back on the basis that His Honour Judge Taylor concluded that the judge had erred in his approach to reconsideration. However, since July of last year, following an order of Mrs. Justice Stacey, there's been a stay.
Everything's been stayed in the employment.
Everything has been stayed, and that includes the work of the independent experts who've also stopped their labours in relation to this case. And we'll come on to it, but Mrs. Justice Stacey's disposal order provided for an exercise between the parties to put in tabular form an analysis of the judgments thus far. And that is intended to be concluded after the hearing of this appeal, depending upon, obviously, the conclusions and the outcome of this appeal, to which I'll come very briefly by way of introduction in a moment.
Sorry, can I just understand that? Do you mean it has been deliberately postponed until they see what we say, or simply it's been going on and hasn't yet got there?
No, it's been deliberately postponed. And the only thing that's happened is that the parties have exchanged samples of their approach to that table, and it must be noted, and we refer to it in the judgment, that we are not in agreement about the exercise that is to be undertaken interpreting what Mrs. Justice Stacey contemplated. And recently, the lead A claimants, I think, together with the Harkers claimants, have written to the EAT, and we have yesterday written to the EAT seeking the possibility of a further hearing from Mrs. Justice Stacey about how those matters should be addressed. All of that is going on, but, and I say but, because I acknowledge that when you approach this appeal, you may look at it, and in particular the disposal that we seek, with a degree of alarm, because the alarm will be sounded by the prospect that what we say should happen at this stage is that we should simply remit this matter back for a rehearing.
Start again.
Start again, but not quite completely start again, because what we do know is that the parties refined and narrowed down their points of dispute, and indeed, even in the course of the hearing, were able to agree previously matters. So there's a hope that the progression of the evidence that has happened and the exercise of cross-examination that took place will enable them to close those issues down more. Transcription is important. All of the previous hearing was transcribed, the whole hearing. So all the evidence that was given before the tribunal was transcribed to the extent that there are disputes. So although we contemplate starting again, and although we contemplate that should be for a new tribunal, because of, we have to say, where we are, we don't contemplate that that is a de novo exercise that will not gather speed from where we've got to or where we stand. I know it sounds unattractive, but we have to look at the alternative. And it's an alternative against the background of something like 60,000 claims, something like 36,000 claims in relation to this tranche of significant value, and a need to have clarity and certainty about what is being specifically found. And what we see effectively being argued by the respondents to this appeal, I understand why, because essentially they look at where we are and they can see enough in it where we are to pursue matters further. But the reality is where we are is that what we're left with is 5 judgments acknowledged to be inherently including errors of law, because the effect of the scope appeal is that there are parts of the judgment which are reflective of an error of law on the part of the tribunal. So we have good parts and bad parts, and we have the prospect of trying to assemble out of this process by an exercise being undertaken, if you're not with me on disposal, to try and salvage some particular process.
Is it a bit overstating to say 5 judgments? If the matter were to proceed, would it not be enough to start with the second judgment, the July 2024 judgment, and the reconsiderations? Because, and obviously all that went before is highly relevant to some of the grounds of appeal. But if you were not to succeed on those grounds of appeal, or on those which are said to relate essentially to what the ET got wrong in its first decisions, the only question is, are there any errors of law in the July 2024 decision, subject to the reconsiderations? Isn't that really, in terms of the future of this litigation, that's what everyone will be looking at if it's allowed to go ahead?
So if you say allowed to go ahead in the sense of not remission for a rehearing, setting aside that process. Yes. So if you were against me in that primary position, it's true that obviously the grounds I advance are freestanding, and in particular aspects of them challenge parts of that decision in any event. So there is an outcome whereby I succeed on all or parts of my appeal, but it isn't an exercise of starting again. It's an exercise of remission for reconsideration on the basis of those allowed appeals, and that is an outcome. But I start off by outlining why we take a dramatic approach.
I suppose I was really dealing with the consequentialist argument. Purists would say it's probably irrelevant anyway. What are the consequences of the disposal you're seeking? And you were saying everyone will have to go back and look at 5 judgments and it'll be a terrible mess. The truth is everyone will have to go back and look at 1 judgment and 2 reconsiderations of that judgment, which only attack particular aspects of it. Is that not?
That is true. Although even the exercise of looking at 1 judgment and the 2 reconsideration exercises, when we look at the detail of it, involves a high level of complexity. I mean, it may depend.
I'm sure, and of course, part of the argument I think is going to be, if I've understood the judgments correctly, even the July 2024 judgment, though it shows the tribunal setting off, finally doing something like, not everything, something like the task that it was asked to do, is flawed in many ways and just unworkable. It's too. But speaking for myself, at least not now, but when you get to it, I will be interested in focusing in particular on that judgment and seeing whether that could be worked with as Mrs. Justice Stacey thought it could be.
Yes.
With some further help.
Yes. Though, obviously, there are two questions in relation to that. The first one, I hope to demonstrate that it is fundamentally problematic and impossible to unravel without something. There's a subsidiary question, which is, if one was to do that, is it remission back to the same judge in relation to this exercise?
Well, I see that. But I mean, I'll shut up for the moment. I was provoked into making these remarks by your suggestion that we'd have to go back and look at all five. Really, the operative judgment now is the 2024 one with the reconsiderations. That's the one that, if nothing happens, will go ahead.
Yes, and that's the judgment that we have from 2020. From the judgment that we have, the substantive judgment of 24, is the subject of my appeal.
Yes, quite.
So you're
Okay,
right
well,
to that extent.
I've said enough.
No, and I acknowledge that it was me that took us to the question of disposal rather oddly at the end, because I wanted to demonstrate the difficulties which we see in relation to them, and also to herald something which I know from previous experience will be said against us, and that we say is a fallacy, that in some way this is all about Tesco trying to delay litigation. The truth of it is, unfortunately, this is complex and difficult litigation. Everyone needs to focus inevitably on specific and narrow points, and everyone has fought the litigation hard and close. I counted up, and there have been 17 appeals to the EAT and 4 appeals to the Court of Appeal in relation to the history of the litigation. They are not all appeals by Tesco. The other parties have also appealed. And what has caused a serious delay ultimately in this case, and we don't perhaps need to go into the minutiae of who's responsible, but we bridle at the suggestion that we've delayed it, is that the substantive hearing in relation to this stage 2 process, which, as we look at it with the greatest respect to the Employment Tribunal before, is a tedious exercise, but essentially a factual exercise determining points of fact between the parties on which there really wasn't any substantive legal issue. That took place in March of 2023, the evidence process. March to May of 2023. And really everything since March to May of 2023 to where we stand now has been around the problems about the way that the tribunal dealt with this particular process. And although it'll be said that there's more delay or yet a process of delay, the reality is that actually to progress this into some semblance of order, recognising the need for clarity for a process that's going to have to determine the evaluative exercise of these jobs, a step back is more likely to lead to a step forward. Just so you know, the litigation itself has not stalled because, consequent upon an order of Judge Hyam, the material factor defence that is being advanced in relation to the claims was listed for hearing and is being heard in May of this year. I should say that disputes in relation to the instruction of experts in relation to that itself led to 2 successful appeals against decisions of the employment judge, and one appeal that was refused on conditions of this court, but it's now progressing in May. I should also note that
In front of Judge Hyam, or
no, so it was it was listed in front of Judge Hyam, having had the second appeal overturned in relation to decision on the expert evidence. I understand that it has now been reallocated for material factor to a different employment judge in that region. and again, on the prospect of where we go, and this works, I acknowledge, both for our rip it up and look at it again, but on the basis of what we have, or indeed your Lordship's observations about reconsideration. We actually have, in February of next year, a listed hearing that was originally intended to be stage 3 of this case, with the independent experts having reported. There's no prospect of that happening, but the parties at least have a block of time, I think, for 6 weeks, listed in the Employment Tribunal. I think it's 8 weeks, I'm told, in front of Judge Hyatt. So if I'm right, whether I'm right substantively, starting again, whether I'm right revisionist in relation to the July judgment, the overall scheme of this litigation is going to practically have to involve that exercise then. Unless, of course, we are successful, as we anticipate being, in material factor defence, in which case the exercise falls away. So that's a long introduction, but I hope to try and set a context for where we are.
Can you just explain that last sentence, the material factor defence,
Yes.
and the whole thing falls away?
Yes, so in the context of this type of litigation, the claimants identify the jobs that they say are of equal value. Stage 2 is determining that. If they're found to be of equal value, it's open to the employer, then the claimants point to terms which they say, my terms should be amended to be the same as my comparators' favourable terms. It's open to the employer then to say there are genuine material factors, not tainted with gender, that explain why those terms are different, and that's a defence to the claim. I put it very, very succinctly because there are aspects of it involving inferences of indirect discrimination, but that's the central defence point. And in the other cases, in some cases, the whole process of evaluation has been concluded before material factor defences have been considered. Here, the employment judge decided that because of the time that it was likely to take about the independent experts, that the time could be usefully used by determining material factor. I acknowledge that we appealed that decision because we considered that it was difficult to deal with the material factor until you know exactly what you were dealing with.
What the facts are about the jobs.
Sorry?
What the facts are about the jobs.
Yes.
Yes.
Historically, I think it was quite common for employers to take the material factor defence. They assume everything you say is right. I can still show it's because it's a different region or some defensible historical reason. But that rather fallen out of fashion, I think, hasn't it? The general line is to decide, first of all, as my lady says, factually whether the jobs are of equal value, and only then to decide whether that could be accounted for by a different fact. But sorry, I should have restrained myself. This doesn't really help us.
No, but the point you make is true. Here, different approaches have been taken in different cases.
Yeah.
But
We have this approach in this case. Yeah.
In this case, material factor is being determined in May of this year. And in answer to my Lordship's question, if that defence succeeds, subject to appeal, and history would tend to suggest that without tempting fate, that may yet prove to be what would happen if we did succeed on the part of other parties, that material factor would mean that you don't need to determine the question of equal value. If it was found against us, or it was successful in relation to certain jobs and not others, then again it would modify and change the equal value exercise. But where we are is that this is not inaction in relation to the litigation at this particular point in time. The stays have only impacted upon the equal value exercise, not upon material factor, and that's progression.
And how long do the independent experts typically need to do their work once they've given you material to do it?
Experience has taught us that the independent experts is a very small panel of independent experts, and they appear, perhaps we don't need to go why, they appear to have a substantial body of work on that they have to engage with. They, I think, originally contemplated it would take at least a year for them to produce their report. They undoubtedly started off doing some aspects of preparing, because we can see in communications to the tribunal, they were doing test exercises, but they paused. And it's not simply also a matter of the independent experts, because what tends to happen, subject for the permission of the tribunal, is that the parties frequently instruct their own experts in order to consider the evaluation process that's gone on. And the hearing embraces not only the independent experts, but partisan experts and submissions. And so obviously you need time after the independent experts report, because it's the first report, to consider that and report your own experts. So that's why I say that what was originally contemplated back in 2024 as being a long, sensible lead time before having a stage 3 hearing in 2027 has been eaten up by the tribunal's overarching approach in relation to that. So I don't know, but if we were to recalibrate the entire exercise, and even what's contemplated by, if I was to walk out now and abandon this appeal, no fear I'm afraid that I'm going to, but if I was to walk out now and abandon this appeal, and we were to progress with what we regard as being the time-consuming and now apparently fraught with dispute exercise of Mrs. Justice Stacey's decision, we're not going to get to the end of that process and a settled set of job evaluations before we've gone back to the tribunal, having undertaken her exercise to identify things that the tribunal need to determine where we're unclear as to their resolution. We're not going to get to a settled set of job evaluations. It's hard to anticipate that that's going to happen much before the end of this year, even if we do that. So other litigation, and we will have a little bit across in a moment to, when we look at how things have gone wrong, the way that other litigation has happened. Other litigation has moved through this stage 2 process. It's been time consuming, but structured, and the outcomes have led to job descriptions for the purposes of the independent experts, which were resolved and settled, and the independent experts were able then to progress.
Just on these background things, there is other, if I might call it this way, supermarket equal pay litigation going on. It's not just Tesco, is it?
Yes.
All of the big supermarkets.
Yes.
Is this the furthest advanced? I think
no. They're all in slightly different positions. So
don't need detail, but broadly,
broadly. So ASDA, which in fact is the largest multiple, I think there's something like 100,000 claimants in ASDA, that has gone through the whole of its equal value exercise and had a stage 3 hearing, which I think took about 3 months.
That's the genuine material factor hearing.
Now it's got material factor, but I think that decision, as I understand it, I'm not instructing ASDA, but I think that decision, the stage 3 decision, is subject by appeals by both parties, but ASDA now needs to move to material factor. Not all of the claimant roles succeeded, but that's refined. Morrison's has progressed through stage 2, but has a material factor hearing this year. Yeah. And stage 3 is to happen. Sainsbury's, I understand, doesn't have a material factor defence, but is progressing along the equal value exercise, and co-op is in the stage 2. There is other litigation involving boots. I think
Unless my lord, my lady are interested, I just want the answer is is other litigation, as I understood, at various different stages. Possibly Asda is the furthest advanced, but they all have their own different structures.
yes, they all have their own structures, but obviously the underlying legal principles aren't the same.
Yeah.
The process and the issues and the number involved in the multitude is different, and obviously it's the same pool of independent experts, quite aside from the demands upon them of other non-supermarket generic equal pay litigation who've been called upon to do this process, and that obviously impacts on the consequences of delay. And so we'll briefly look at some of those other litigation, because Mrs. Justice Stacey rightly looked at, and this partly her touchstone in trying to get a disposal order that put in the structure, looked at the way that litigation had progressed by comparison with how matters have progressed here. That's by way of introduction. Can I? I'm going to track through my skeleton argument. There are a couple of points by way of the background and the introduction that I just wanted to highlight. I mentioned the position, which is really where the respondents to this appeal, the claimants, want us to be, which is to have a judgment effectively which is acknowledged to be erroneous, at least in parts. And that's a practical consequence of the fact that the EAT allowed 8 in full. I make this point at paragraph, or rather we make this point at paragraph 1.5. The EAT allowed 8 in full and 2 in part appeals against that substantive judgment of 2024. And that led to the disposal orders. I think my learned friend on behalf of Claimants suggested in some way that was a limited exercise that had limited impact in relation to it. We think that there are in excess of 1,000 points of issue that need to be reconsidered on the job descriptions that were being looked at here as a consequence of what we succeeded on in front of the AT. Now, acknowledging some of those will be quite straightforward because it's quite clear that the parties are in agreement about what should happen as a result of our success. Others are far more complicated. And in that, in part, is where we've all run into heavy weather in trying to deal with the disposal order. And at the heart of this exercise, what we say this reflected, and this is the overarching problems that we identify in the judgment, is that in approaching stage 2, which, as I indicated, is a tedious but almost administrative exercise in determining disputes of fact, the tribunal approached it, possibly erroneously, in an attempt to try and short circuit or process that, adopting 2 errors, fundamental errors. The first was that they erred in their approach to what work was, which we say the EAT gave a benevolent view of, but actually, when you look closely at the judgment of the tribunal, they persistently indicated that they were taking an erroneous approach to what work was for this exercise. And it's entirely right to assume that, having consistently directed themselves erroneously, that's exactly what they did. And that's a fundamental problem about the entirety of the judgment. It's not an exercise of picking bits out. And
Isn't it also supported by the prominence they gave to the training documents?
Well, that's exactly right, because that's the second. That's really, these two things sort of align together, because when we look at the detail of it, they essentially are concluding, well, the training documents are determine, this is their central error of approach, determine what the employer required to be done, and took that approach whether or not an individual had actually had that training or not, and without having regard to what an individual was actually doing. And that obviously feeds into the second problem, which is that we identify this at 1.6, which is instead of making a cohesive exercise in terms of findings a fact in relation to the case, what we see is them incorporating chunks of training material and citing passages of training material rather than making determinations of questions of fact between the parties. And that leaves you with the problem of trying to work out exactly what they decided. And if we look at the background to this, and we look at the way that the parties approached the hearing, this was thoroughly case managed as a piece of litigation. I think, in fact, there was a change of employment judge following, I think, the retirement of the original judge charged with management of the litigation. But there was a close management of the litigation. And what that led the parties to is the preparation of job descriptions. And classically, the way this litigation works is that the claimants prepare a job description for the claimant roles which have been identified, and the respondent identifies a job description for the comparator roles. And a curse on all your houses, you might say, because all the parties have reached this point, you might think of a job description as running to 20 pages. The job descriptions typically in this litigation are all well in excess of 100 pages, if not up to 200 pages. And that's true of everyone's job descriptions. They identify with a high degree of precision what it is that's said to be engaged in relation to particular roles. And having received the other party's job description, you look to see if you can agree. And when we look precisely at the rules, the objective is to see if the parties can agree what's involved in relation to the work for effective purposes. And if they can't agree, to identify the specific areas of dispute.
Is it typical in this kind of litigation to have 100-page job descriptions? And you say both sides took this approach. Claimants did incredibly detailed ones, you did incredibly detailed ones for the comparators. My reaction, I'm bound to say, is the same as that very belatedly of the Employment Tribunal. This is just far too much detail. Can't be necessary for the kind of exercise that the regulations and the statute expect to be done. My very limited experience of these cases from a long time ago is that job descriptions were much more economical. I mean, you said you wouldn't expect you to look at about 20 pages seems to be quite unnecessarily long.
Yes. Well,
and the 100 pages is ludicrous, isn't it?
The reality is, and in the danger of coining a phrase which might haunt me, points mean prizes in relation to this exercise for both sides. When they look at the jobs, they reflect on the fact that they each need to be absolutely clear about anything that's likely to sound in relation to the evaluative process. And everyone leads to a situation where the job descriptions become very, very detailed.
If one was starting with a blank slate and case managing it, might the Employment Tribunal say, guys, the job description shouldn't be any longer than 50 pages? I mean, it's too, it's bolted.
I note what you say, Mo.
Yeah, I mean, it just strikes me, but it's too late now because the parties weren't stopped from doing what they did, and they pitched up at the stage 2 hearing with what they had.
Yes, and I think again, in fairness to the parties, when we look at it, the independent experts gave guidance to the parties as a form of job descriptions, and although in fact they obliterated, in truth they are the job descriptions from ASDA. For a couple of, not the whole ones, but as part of guidance to the parties to completing that particular exercise. And one of the things that the independent experts encourage, which adds to the length, but I think ultimately in this case the parties moved away from, is they give an indication initially of what their provisional factors might be as to how they evaluate jobs, and encourage the job descriptions to identify where these might be relevant in relation to factors. And that can lead you into longer and greater disputes. And not in this case, but in another piece of the litigation in another case, and not any of these claimant lawyers, I saw one which was 275 pages long for a team leader role in a supermarket. But that's where we are.
Well, without prejudice, the lady makes an important point that we are where we are. Both parties took this approach, you say, with some guidance from the independent experts. But it may be that in any eventual judgment, we might want to say something deprecatory about this approach. It's very hard to believe that it's necessary or proportionate. Very important though these decisions are for both parties. But think about that. If you want to dissuade us, say no, it is actually essential to have 100-page job descriptions for, I'm not being anybody rude about, but jobs which are not difficult to comprehend. We might need to say something more about that at some point during the hearing.
Well, I note your observation.
Okay.
I'll take you no further. We'll reflect on that. No doubt we all have a view in relation to where that stands.
Well, you may want to dissuade us from trying to reinvent the wheel. And certainly, it's maybe too late to say this is what went wrong here. But people will look at our judgment to be the first judgment about this kind of thing. It may be valuable if we say something that makes people think again about the approach they're taking to the length of these descriptions. But again, I'm not going to say anything more about that, but it struck me very forcibly when I started reading this material, and I wanted to flag it up now rather than later. No need to say any more.
We'll reflect on that. Can I just take you, because I think it's important to see it in the context of when we look at it where matters, we say go awry in the tribunal's approach, not least in relation to the double point of incorporating training documents and relying upon training documents in this phase. Can I take you in the, I think it's in the supplemental bundle. I'm sorry that it's not in the core supplemental bundle, and it's at page 902.
Do you know which tab that is? Because my volumes...
I didn't know that you had tabs. I'm sorry. That's so hopefully someone might tell me that.
We neither have tabs or page numbers on the spine. So
902 is 55.
Sorry?
Tab 55.
55.
That's volume 3.
I'm very grateful. Thank you. I hope what you should have there.
Sorry, it's 56.
I'm sorry, tab
56.
Tab 56, I'm told. I'm alarmed to learn that you don't have a paginated version.
Now, what I meant was, usually in a well-constructed bundle on the back, it will say which tabs appear in this bundle and which pages appear in this bundle. Doesn't matter, but
I apologise for that. I haven't guide, I don't have it broken down to tabs. But anyway, if you look at that page, what I've taken you to is that the way that the case management exercise in relation to this litigation, the way the case management in relation to this litigation evolved, led to a records of dispute. And I've just taken you to one, which is Mr. Jones, who's one of the comparators and worked at a Tesco distribution centre in the ambient, the non-fresh food section. And he did assembly, which involved assembling ambient goods to be shipped to Tesco stores. And he has significance in the way that the tribunal dealt with matters, because what they did, and you'll have seen it from their judgment, is that when they gave their judgment in 2024, they had appendices dealing with the individual claimants and comparators. When it came to the comparators, that was Appendix 8, they made findings about Mr. Jones as a sort of anchor comparator, and then went on with the other comparators to identify anything that was different in relation to their work and make findings in that respect. So what this is showing is an updated document, and I take you to it because it shows how the parties progress to a hearing. You'll anticipate that we've got a very small section of what is a very long document, but what you'll see if you turn to page 903 is the way that it worked is that having had those detailed job descriptions, those were broken down into individual elements, and the parties' respective positions were set out. And we don't have the headings of the columns, but what we have is the second column in is a descriptive passage setting out the element of the job description.
Sorry, but who wrote that first?
That's written by Tesco in this case. The claimants would have the same exercise, but they would have written for their clients that description. The next column involves points of challenge. Now that might involve a complete rejection of the term. It might involve a modification of the wording for the points of issue. And the next column involved a summary of why the claimants were challenging that. And the third column set out...
Give me the third. Sorry, I thought... The one that says factual dispute, that's the third. Or is that the fourth?
sorry, yes, that's included by the claimants.
Yeah.
And the last column is is Tesco's response. Now, if you just look at the top of page 903, you'll see that it says, in fact, extracts from the appellant's closing submissions for Wayne Jones. So what's happened is that originally there were records of dispute. As the evidence progresses in the case and at the point one gets to closing submissions, some of those have narrowed, others remain live issues. And if you look at 6.94, for example, on 903, you can see that there's a slightly faint text there. And if you look at actually the fourth column, I'm sorry, I should say that, where it says no challenge, you can see that what that's recording is that the claimants agree with that aspect of the description. So what was contemplated, by the parties and what they'd been case managed to direct was that the tribunal would be looking at determining specific findings of fact in relation to matters, and that the output of that process would involve effectively a final column that gave the tribunal's conclusions. It may be cross-reference to a narrative, but cross-reference to the tribunal's conclusions in relation to that process, and that would then enable the drawing together of a settled job description as a consequence of the disputed areas of fact having been resolved.
So just so I understand how that would work, the tribunal at the end of the stage 2 hearing would give its ruling on each of the points of dispute, as you say, either as a final, either text in the final column or a cross-reference in the final column. Someone would still then go away and put together then a single piece of text, i.e. I suppose a single piece of text which reflected the end product of all that. So
Yes.
the independent experts would not work with the final version of this schedule.
No.
They would get a continuous piece of text.
And what the independent experts expected, and indeed we see in the narrative that we communicated to the tribunal the aspiration that this is what they would get but never do, is that they would get a concluded job description. It's going to be lengthy because the originals would have been lengthy, but resolving those matters. And I perhaps don't need to take you to it, but in the hearing before Mrs. Justice Stacey, she asked about other litigation, and in fact in her judgment she refers to Morrison's Co-op and Sainsbury's, and certainly in relation to Morrison's and Co-op, they had both been through those stages. In fact, I act for both of those. And what happened is, as you've described, is that the parties took the tribunal's findings, and then a process was put in place where the party who had ownership of the job description would amend in the light of the tribunal's findings and see if that could be agreed with the other party, with a mechanism for clarification if not. But it's led to a settled job description. So in those litigation, the output of the tribunal in both those cases involved a relatively short narrative judgment, but a tabular outcome reflective of the way that the parties had prepared their case and had been case managed to prepare it. And that outcome was then condensed into a job evaluation, a job description for the respective party. Lengthy again, but that is what the independent experts worked from. And we look a little bit more closely at the process later in the skeleton, but one of the things about the rules is that the independent experts, although they can seek clarification or findings from the tribunal and at any stage, the facts that they have to have regard to in determining that are the facts that have been agreed or decided. And so it's not an exercise of them looking at a wider picture. What they have to focus their intention upon is what this process has concluded. And that in essence is where things started to go awry, because just picking up the narrative, it's in page 6, sorry, it's paragraph, page 5 of my skeleton argument, and the narrative is pulled because it's the subject of the first appeal, paragraph 2.5. The first judgment of the Employment Tribunal, that of the 12th of July 2023, the tribunal took this different approach. And what it concluded was that, and we quote the relevant parts there, that the manner in which the parties had put their evidence and contentions before the tribunal was so inconsistent with the interests of justice that it was not just to determine the fact disputes as they stood at the end of the hearing, And they said that, and this is where we look later at the error of law. They did that is that because the evidence submissions has focused on what the sample claimants and their comparators in fact did, and not on the training given to persons doing the job of the sample claimants and comparators. And that's where we say we see that error being most extant and then subsequently reflected. And I think it's right, to the horror of all the parties, what the tribunal then contemplated was a direction that the parties went away and redid their job descriptions, which had been involved in a case management process for something like 2 years to that point in time, redo their job descriptions, but using the training documents. And that is what was identified in case management order of the 26th of July 2023, that again also forms part of what was the first appeal to the ET. And at 2.7 we note that particular appeal. However, the tribunal, all the parties raised issue about that, not least the cost involved in that re-exercise, and the tribunal changed direction in October of that year, and Mrs. Justice Stacey was critical of this. There is a high volume of communication between the tribunal and the parties, and obviously on one level that's of assistance, but we see quite a lot of determinations or considerations in the tribunal being communicated not in the form of judgments but in the form of emails to the parties. And on the 9th of October, this is 2.8 in our skeleton argument, we're now on page 6, the tribunal took the view that it wouldn't require that, but that it would determine the dispute itself primarily by reference to the training materials. So they've heard evidence. The evidence has been directed to what were the disputes, but their indication is that they're going to determine points on that basis. The claimants, seeing this prospect, produced a joint note as to what they said the law was. Now, it's right to say that at that point in time, Tesco's didn't agree that. They raised a point of issue. Before the AT, we accepted that the joint note was correct. The claimants presented a joint note of how they saw the law, effectively to the point that one needed to look at what actually was done rather than the training, rather than what might be required of parties, and sent that to the tribunal. And that led to the tribunal indicating that it took a different view. When we look at their errors, we'll look at that exchange because it reinforces their different approach. Meanwhile, as I indicated, the independent experts who obviously were waiting on this process were communicating that their expectation at 2.10, we deal with this in the skeleton. I don't need to take you to it, but they wrote to the tribunal saying that their expectation was that the findings would be incorporated into a single job description for each job. And that then gets overtaken by the judgment which is at the heart of my substantive appeal, the 4th of July judgment of 2024. And as I indicated, extensive, 619 pages long as a judgment, with 8 appendices, 7 of which dealt with individual claimant roles, the 8th appendix dealing with a lead comparator and then individual comparators. And that included references to the training documents, and we assess the number of training documents which have been referred to as being about 750, and that running to something like 19,000 pages of material outside the judgment itself. Point 2.12, I've already mentioned this, and I don't take you to them, but for your reference. At 2.12, we refer to the judgment of the EAT, where they cross-referenced the outcomes in some of the other litigation, large ET litigation, and how that had produced a different result with a table of resolution of facts that enabled a single job description to be done. And that led to Tesco's appealing that second judgment of July 2024. In the grounds of appeal, the first judgment from 2023, typically described as being A1 with the individual ground. Second appeal to the AT was described as being ground 2. Just having seen that, it's worth noting again that 2.16, again, I perhaps don't need to take you to the respective document, but in September of that year, September 2024, having had the judgment of July, the independent experts again wrote to the tribunal, raising concerns about their task of doing an evaluation faced with the material that they had, incorporating all those exercises, and they indicated that it would make their work unwieldy and time-consuming, and they asked the tribunal to direct the parties to prepare final definitive job descriptions in the way we've contemplated. The tribunal, however...
Sorry, what's the reference for that request?
That is at it's in the supplemental bundle, page 753. There's also a core supplemental bundle which is smaller, and I think it's at page 118 in that. Yeah, that's tab.
I found it. Yeah.
Yes, you'll find that that's tab 8 in the core supplemental bundle.
Tab 8. Sorry, I thought I may have misunderstood you. I thought you were saying this is another letter from the independent experts.
I think it is.
No, what I've got there is exchange of emails between.
Oh, sorry. Did I say 108? I meant 118. I do apologise. It's tab 8.
Got it. Thank you.
So the 3 independent experts at the bottom of that page.
Yes, thank you. No, that's fine. Yes, thank you.
So the tribunal didn't take up the idea of the parties preparing job descriptions at that particular point in time, and if you look at 2.17 in the skeleton, page 8. In January of last year, what the tribunal indicated is that having considered that, they themselves would proceed to produce individual statements of the work for each job holder. And they indicated they wouldn't direct the parties to do this, and here we say is something which indeed is experience has taught us has happened. They said that we're sure that directing the parties to revise the EVJDs by reference to our factual findings would have been very time-consuming, costly for the parties, and highly likely to give rise to further disputes, which we would have to resolve. And that led to their first reconsideration judgment of the 30th of May. And
So, sorry, yes.
that's tab
Just,
2.
the cross-references in your bundle are in fact all to the supplementary bundle and not to the core.
So not all of them are in the core. I'm
No,
afraid.
so the one, right, that's fine, but
So I don't think if there's a convenient place where it's in the core, I'll give you the reference. The skeleton, I think, was prepared.
don't worry. I just wanted to be clear about that because I was just trying to follow up the references there while you were speaking. But
Sorry, yeah. So
that's fine. Keep going.
So it's 2.18. They produced their first reconsideration judgment, and when we look at aspects of it, obviously no party directly appealed that, although it was a reconsideration judgment, and we have appealed the judgment that is the subject of reconsideration. The tribunal reiterate, we say, their approach of incorporating training documents. They don't change their approach either in relation to their focus being upon what the employer required people to do or the incorporation of training documents, although it's right that some bits of their reconsideration lead them to change their mind about some of their original findings.
So the reconsideration judgment, was that prompted by an application by any of the parties, or was it the ET reconsidering of its own motion?
That wasn't the product of an application by the parties. I don't. Was
We
it?
were invited to apply it, which we did.
Yes.
Oh, you're quite right. You do apologise. You're quite right. It was. So it was the product of the party, but I think everybody applied.
Because the ET invited them to.
Yes.
Yes, I'm sorry. Yes. So apologies. What I'm to be absolutely correct. Their first judgment contemplated applications for reconsideration. Everyone applied.
Yeah.
But what the tribunal did of its own volition is not only revisit what had been asked to be reconsidered by the parties' application, it also reconsidered more widely its first judgment.
I see.
But didn't, we say, change its fundamental erroneous approach as to work or the incorporation of training documents. Again, just to see the narrative in relation to that, that judgment invited again the possibility of the parties making application for reconsideration, and this is at 2.21 on page 9, and that happened. All the parties made applications for reconsideration of that first reconsideration judgment, and that's what led to the second reconsideration judgment on the 28th of July of last year.
Yes, so the first reconsideration judgment is the entirety of volume 2 of the supplementary bundle.
I don't know the numbers. That's probably right. And there's something like.
Well, I think so, and also a bit of volume 3, if I remember rightly. I think.
Oh, right. Okay. Thank you.
In that narrative, and I'll come on to it on the scope appeal, the various parts of our original appeal to the EAT against the judgment of 2023, and the case management order, we changed in the light of their first judgment of 2024, and we had a second appeal, and those were all the subject of a permission hearing in front of His Honour Judge Taylor, sitting in the EAT in February, and we deal with this at 2.19 on page 8. And he, in parts of that judgment, limited the scope of some of our grounds of appeal to examples given in particular sections, and that's really where the scope of it runs, although we say now with much narrower effect, and really not the focus, not the tail that should wag the dog in relation to looking at what's gone wrong in relation to this particular case. And just to, I mentioned it earlier, and just so we're clear on the note, at 2.21, that second reconsideration judgment of July 2025, that's a judgment that's been the subject of further reconsideration applications by the parties that have led to the successful appeal about the procedural aspects to His Honour Judge Taylor. So, absent any process above at the appellate level, the tribunal's exercise of reconsidering its judgments has yet to fully conclude. But where we stand at this point in time is that there are 5 substantive decisions of the Employment Tribunal below, and we've yet to reach a concluded set of facts in the way that was contemplated ever in relation to the parties.
Purely so we have the whole picture, not because I'm sure it's to be central. That EAT judgment of Judge Taylor about the applications for reconsideration, do we have that in the bundle?
You don't. It was only handed. It only was promulgated, I think, last week on Thursday. We haven't added it in. Can I say that it probably doesn't impact upon that?
I'm sure not. It's just in order to sort of tell the story accurately. But yes.
Yes, but we can. We'll get a copy of you for your lordships. Essentially,
don't worry anymore.
If I pick up the story, and I've got an eye on the clock about the break for the transcribers.
We don't tend to provide a break in this court. We generally expect the transcribers to provide continuous service.
Well, I'm happy to go on. I hope that's a message that the transcribers yes. Anyway, so I'll press on.
I think press on. Yes.
So at 2.23, it's page 9 of the skeleton argument. The 31st of July is the judgment that's the subject of my substantive appeal, and that's the judgment of Mrs. Justice Stacey, and as I say, it upheld a substantial part of Tesco's appeals in relation to the tribunal judgments which were the subject of that hearing. It led to a disposal hearing, and normally disposal hearings in the EAT are a relatively quick exercise. This one, I think it was described as being intense by my learned friend on behalf of Lee Day, and he's probably not wrong about that. It was a 2-day hearing to address what issues were in relation to disposal, and it led to a complex disposal order, including, as I've alluded to, an exercise of trying to put in tabular form the process of the tribunal's decision making. As I've indicated, the parties are in disagreement as to how that is operating, not least because we say that we were unsuccessful in our appeal on the point that training documentation shouldn't be incorporated, and therefore we have to look at what the tribunal have actually incorporated. But I perhaps don't need to go there before I look at the substantive point in relation to the appeal. So that is where we are. It's a long introduction to the problems, but the problems rest on errors of law and approach. And the first of those is reflected in ground one of our substantive appeal. For your reference, that's in the core bundle at page 29, and that goes to the tribunal's error in the meaning and determination of work for the purposes of the equal value exercise. And you find in our skeleton argument that begins at the bottom of page 11, paragraph 3. And to look at this exercise, it's briefly necessary to look at the underlying legislative position. And the core point here rests on section 64 of the Equality Act. You find that at tab 4 of the authorities bundle. And in particular, page 73 in that tab, which is section 641. Which is 641. 641 sets out, it's the beginning of sex equality in relation to this exercise. 641 sets out the following sections apply in relation to a person who's employed on work which is equal to the work that a comparator of the opposite sex does. And if we then move to section 656, which is section 65 of the Act, you find that on page 75 of the bundle, that sets out a structure for when work will be found to be equal. You'll maybe familiar, I know some of the court is familiar with section 65(1), that there are 3 ways of addressing that. It may be that it's work which is like B's work, and that's an exercise in looking at work being broadly similar in nature. Work that's been rated as equivalent, and that's where an employer has actually undertaken a valid non-sex tainted job evaluation study and found that work is equal in a grading structure, or this case, where it's alleged that work is of equal value. And if you look at the next page, subsection 6, the critical point is A and B. So the previous, if you've gone through the previous ones, you're looking at jobs which aren't broadly the same, not rated as equivalent. The last category is nevertheless equal to B's work in terms of the demands made on A by reference to factors such as effort, skill, and decision making.
And the short point is it's not demands made by the employer, it's demands made by the work.
Yes. And I note in passing that one of the slight issues in relation to this exercise is that there is no specific definition of work, and also when it comes to evaluation in relation to this exercise, not relevant for our purposes but worth noting that actually there's relatively little guidance for how the independent experts will assess those particular demands, and clearly it's going to significantly depend upon how they identify from the material they have what the demands of the job are, and how they evaluate in factor terms, how those can be evaluated in terms of factors such as, so other factors may be included as will identify the demands of the job. And when we go back, to the line of authorities, consistent with the fact that one's looking at the demands of the work, the focus of the authorities is consistently about looking at what actually people do in terms of their job. And there may not be, as I indicated, as it evolved and before the AT, there was no substantive issue between us as to what the law decided in relation to this. The decision of the Court of Appeal in Shield and Coombs Holdings, which dates back to 1978, a case which was actually concerned with the like work rather than equal work definition, focused specifically on what the work required to be done. And we include the references there. I'd probably not necessarily have to take you to that case in the light of the fact there isn't issue between us. I would take you to a passage in the Court of Justice in the Brunhofer decision, which is a later decision and directly engages with an exercise in equal value. You'll find that the Brunhofer decision is in tab 19, and it begins at page 235.
The first of the authorities bundles.
Yes.
That is correct. I think there are two, I think, in that it's the first.
What was the page? I'm sorry.
It's 23. The judgment is at page 235.
And where did you want us to go?
I'm sorry?
Where did you want us to go?
In that judgment, well, in the judgment, could you go to page 250?
Thank you.
Just to note, this was a case involving employees who were notionally on the same grade, but if we translated it to English terms, it wasn't a grade that had been the product of a job evaluation exercise. So what the court was being asked to consider was, even if you got two people who were notionally on the same grade, how do you determine whether or not they're actually engaged on work of equal value?
Wasn't the particular issue how hard they were, whether the quality of their work, so to speak, whether they were good at it,
Yes.
was a relevant consideration.
Yes.
And indeed, each of these cases, don't want you to go behind the joint statement on the law, but each of these cases are on rather different kinds of facts. They're to do with notional, they're all cases that got into the courts because the employers were relying on notional demands which were never actually required in practice, or in Brunhofer to this particular question about how hard they worked.
Yes.
Isn't that right?
I suppose I haven't looked at it in that perspective. I don't think it changes the perspective of looking, as the court directs us to here, at looking at what people actually did in terms of the process.
Yes, but you can have a proper situation, which I don't think any of these cases are directed to, and probably doesn't arise here either, where you do have a responsibility or a duty which only comes up occasionally.
Yes.
Or when it comes up is important
Yes.
and is something that's properly reflected in what you're paid or how you're graded. And going on about how you must look at what people actually do day to day is capable of resulting in a wrong approach, because it overlooks rewardable factors in the job, if I can call them that, which don't happen day to day, but don't perhaps happen very often, but are part of what you're properly rewarding someone for.
Yes, and I think we perhaps don't need to go there, but in the Potter equal pay litigation in relation to the NHS, there's a passage, actually a first instance passage, which is sometimes cited about the fact that there may be something which is part of the job, which only occasionally happens.
Yeah, well, I think that's probably the line of authority I was thinking of.
Yeah,
anyway, but I don't want to. I just want to flag it up in case it becomes relevant. That all these cases, the courts always express themselves by reference to the kind of issues they have in front of them.
Yes.
And I just want to mark up that certainly, unless you persuade me otherwise, talking about what the job actually requires, what the job actually is capable of slightly misstating the nature of the exercise, because the job may require things that don't happen very often. And I'm not going on about it, but
yes. Well, can I take that point? But observe...
It probably doesn't arise on any of the issues here, but because we're talking big picture at the moment, I just wanted to.
Yes, yes. Here we're very much looking at what people did, and our evidence, and indeed the evidence that was being led by all parties, because it's a very point of criticism which the tribunal says the parties had prepared and misapproached it, was all focused on what happened in practice, which obviously links into the training question.
Yeah.
The passage, obviously,
Brunhofer, I distracted you.
Yes, there's a passage that begins at 42, paragraph 42, at page 250.
It's the nature of the work actually performed.
I'm sorry?
The nature of the work actually performed.
Yes, and in particular at 49.
Well, perhaps we should just note that in 43, in deciding that question, the court mentions among the things you should take into account are the nature of the work, the training requirements, and the working conditions.
Yes. And on training requirements, they picked that up again at 48. Obviously, when we come to training, actually the fourth ground in relation to our appeal, the focus is, we say, on the training that people have had,
well,
as opposed
fair
to...
enough, but so we didn't have to come back to that. I just wanted to flag.
No. So I won't bring you back to the relevant passage.
But 49, you were saying, was also relevant.
Yes.
Can I be sure that I'm clear as to what the status of a CJEU judgment is these days? The wording we find in the Equality Act is presumably derived from Article 119 of the treaty.
Yes. So there's a sort of slightly complex history in relation to it, in that we go back in time to equal pay, predating our accession to Europe. And at some point in that process, I forget when, the concept of equal value came into our legislation. I think that had its origins in Europe. And the Sex Discrimination Act had sections which were modified to give effect and were interpreted so as to give effect to the directive. And then when the Equality Act was brought in to effect in 2010, the idea was to restate clearly the position of the case law.
Yes,
So
it
we
wasn't technically a consolidation act. It wasn't technically a consolidation act, but it was in spirit a consolidation act.
Yes, yes. And there's authority to the effect that the intention wasn't to change the way that matters addressed. So we read it with the benefit of the jurisprudence of the Court of Justice and the domestic.
My Lord's point was partly about Brexit.
Yes, it was. I mean, obviously, when we were a member state of the EU, we were obliged to comply with the treaty, and you had to read domestic legislation conformably with the treaty.
Yes.
Now we are no longer a member state. The imperatives are not the same. But so what is the status of the judgments of the CJEU on the treaty?
Well, I think there are two answers to that. One that I didn't take you to it, but I would say that the case law that we saw back in Shields and Coombs and the Court of Appeal was consistent with what the Court of Justice was saying in Brunhofer. You look at the work. And so so the underlying substratum of the interpretation of the Sex Discrimination Act has remained consistent regardless of EU law. The second point, which is a rather more tedious technical one, is that these claims, and it will be said against me, they're old claims, but they were brought, I think it's 2018, I think, is where they started.
So they're
And going back 6 years. So I
they're
think
pre-Brexit cases.
pre-Brexit. So the earliest periods of time would embrace a period where
Well, they're before the end of the transition period.
Yes.
yes.
No.
So I've not seen a Brexit point in this effectively.
No.
And indeed,
Thank you.
my recollection is that pre-Brexit case law is still prima facie binding, though by a subsequent twiddle,
Because it might be
we can
retained
depart
EU
from
law.
it in very limited circumstances.
Yes, and to be you are essentially right that you can take a view that you can depart from it because it doesn't constrain you. I don't think anyone here is inviting a revisionist view of what is the settled approach, and that would break ranks with where we were at least before Mrs. Justice Stacey, that there was some degree of unanimity about what it was at stage 2. The law was about the expectations of the Employment Tribunal.
Can it be summarised as everybody has agreed that the law that we have to apply can be found in the CJEU cases?
Yes.
Yes, thank you.
And then what we turn to, having seen that, is really, we say the essential point. It's 3.4 in the skeleton argument. That taking my Lord's point about something that might be something that is acquired occasionally or erratic or important, but only something which is intermittent. When it comes to determining the work, and that critically being what one looks at the demands of the work, the question is not what the employer might expect or require of people, generally in the same role, but what the employer might expect to require of the particular job holders themselves under their contracts, under their job. It must follow, and we say it follows what they must be trained to do, actually trained to do. So the point is, what are they doing? Taking my Lordship's point. And I don't need, I think, to go to Beale and Avery Holmes because, again, there was no issue between us before Mrs. Justice Stacey that in a first instance judgment, rather unusually for an equal value piece of litigation in the High Court.
The High Court got jurisdiction.
It does. What typically happens is that the High Court transfers it to the tribunal.
Yeah.
But thanks to the Birmingham City litigation, it's been clear that the tribunal, the High Court, does have jurisdiction to deal with equal value claims effectively, because the effect of the equal value mechanism is to contractually vary the contract. So even if you can't bring a tribunal claim, you can bring a claim in the civil courts.
Oh, actually, a contractual claim based on that.
And
clause.
there's a mechanism.
And there's there are limitation advantages to doing so.
Yes, 6 years in England, 5 years in Scotland. So it's not uncommon. I honestly don't know if there are in this case. It's not uncommon for people to bring the High Court claims as well. But the general approach has been that the tribunal claims are then advanced and the High Court claims are stayed. But this was an unusual. I don't quite know how this happened. I don't think it's important. Mr. Jones was in this case, in fact, so he may recollect. But for the purposes of this litigation, I don't really need to go there. That was looking at the issue in particular of whether or not things which an employee might do which they hadn't been instructed or required to do, to which they did, but the employer took no objection to. I don't think it.
It's all a bit irrelevant, isn't it?
We say it's really irrelevant to this core process.
Not binding.
What we really get to is the way that the tribunal have misdirected this particular exercise in their approach, and they don't just do it once. They consistently reiterate that this is their approach. And you see it first. If we go to paragraph 3.9 on page 14 of the skeleton, we have a subheading, the ET's approach. You see there that we're tracking back here to the first judgment of the tribunal. And it's paragraph 3. You find it in the core bundle, and it's tab 16, and the page I'm at is page 208. And I think in here, I think we highlighted in the skeleton paragraph 3, but actually it's of assistance to read 2, 3 and 4. Because in a nutshell, one has the laying down of a path that leads to where we find ourselves. At paragraph 2, they describe, I think it's slightly misquoted in some of the skeletons from the claimants by saying that key documents, their phrase is the key documents. They say disclose some, but possibly not all of what the tribunal has concluded are the key documents. Those key documents being which are the best evidence of in-person training given to persons in the jobs of the sample claimants or their comparators during the relative period, or which themselves constituted the training in which they were to be read and applied by persons doing the jobs of the sample claimants and their comparators during the relevant period. Just pausing to note, they don't say the training that the individuals had. They're looking at the generic training documents, which they describe as being the key documents. And they then go on to 3. They slightly misstate the respondent's case, and I'll clarify that. But at 3, they say that the respondent's case was the training documents were only relevant if the sample claimants or their comparators had in fact received the training described in those documents.
Is it that sentence that was misstated? It does seem to me to be an overstatement.
Yes, So our position was we don't say they're irrelevant, and we certainly didn't question the fact that the training documents may be relevant evidence in determining what people actually did. So they have a evidential relevance. They also have a relevance to whether or not people actually had the training, because that's a demand of the job, whether or not someone has actually received training. If they're doing a particular task and they've not had training on it, the training isn't a particular demand of their job. So,
no, but suppose there's training how to deal with stuff on the dairy counter, you know, where you put the ice cream, I don't know what it might be, but and there's a training manual about that, and it isn't established that the particular claimant ever had that training, or maybe there's evidence that she didn't. That even then it wouldn't be irrelevant, because it might nevertheless show what she was expected to do, even because which she would have learnt in some other way. On the whole, and unless proved otherwise, if something is how people are trained to do the job, then that is how you would expect that they would be doing the job day by day, unless there was clear evidence to the contrary.
yes, so I think we have to unpack that a little. So I acknowledge that there will be circumstances, and without going into the evidence, I think there were cases where it was said that someone learned how to do the job by doing it with their colleagues and hadn't gone through a formal training process. Now, I acknowledge that the training material might be of assistance evidentially in identifying aspects of that, because there may have been other people who've been trained or they knew how to deal with it. But that isn't what the tribunal, as we see, do here. They reverse the proposition and say the training document is king. That is what the employer required to be done, and therefore we read the training document as being the touchstone to decide what work is. And that's important for a second point in relation to your point, which we say without going massively into the detail in relation to exercises, we say was important for for at least one of the comparators. It may be that someone has, and this to an extent is where Beale might be relevant, might have evolved a way of doing the job that actually is different from the training material, but no one takes any issue about. It's an accepted way of doing it. That means that's still the work. Now, it might mean that they're atypical, or, that's a different issue, but it still means their particular work is how they deal with it.
Can I just deal with that atypicality point for a moment? Is this conceptually the right approach? Employers can only be expected, and the whole system would break down if employers didn't do a degree of generalisation in describing jobs and allocating them to grades, which in turn determines pay. You could, but it's almost inevitable in a huge workplace that someone somewhere will be atypical of the grade into which they've been put. You could say perhaps they've been misgraded or something like that. The right way to deal with that, which may or may not work as a matter of law, but the right way to deal with that is if that atypical comparator is opportunistically picked on, is to use that as a genuine material factor defence. That came up, I think, in the Cobalt litigation. There was an atypical comparator case.
Yes. Yes. I mean, there is this conceptual point that when it comes to equal pay litigation, claimants are liege, comparators are singular. So there is a tranche, there's 36,000 in relation to this exercise. There may be a point, and there will be a point, that in that 36,000 claimants, people described as doing a particular job may not be doing it exactly the same way. But ultimately, when it comes to comparators, the way the law works is it's individualised. So they have picked a particular comparator, having seen their particular disclosure. And I acknowledge that if that particular comparator, the demands for that particular comparator are different in some way, there may be a material factor defence to explain why they are different. And the fact that they're on particular terms which apply to the whole of that grade doesn't mean that there isn't a defence to explain why you shouldn't move to that particular term. So atypical can work out like that, but you're still looking at what that person does. In the same way as ultimately the claimants, you still have to look at what the individual claimant does, even though they may have a job or role that's a generic title. It's still necessary to look at what they do, because although perhaps ill-constructed for class litigation of this size, the construct of the legislation is to look at an individual comparison.
Yes, but at some point in the analysis, you have to fit in the fact that employers can't have individualised pay grades and pay levels for everyone based on some very nice evaluation of exactly what that person does for 36 hours a week or whatever it turns out to be. It's just not the real world. So there's you have to fit in the reality that grades have an element of generalisation in them at some point in the argument.
Yes, and
sometimes you can do it by saying someone has been misgraded and try and rely on that as a gender material factor defence. But I think actually the law has come down that you can do that. But you can see I'm just pushing back slightly at the idea that the only thing that matters is what every individual does, and that, as it were, what is characteristic of the generic job is wholly irrelevant.
I have to be careful about how one addresses your question. I entirely accept that if one's looking at a broader context of the way that material factor works as the defence, all those issues, the atypicality of a particular role or structure and the way that the employer works about pay may be material in relation to it. I'm looking at the exercise here of the stage 2 process.
I know you are, but I'm suggesting even there may be some element of the generic requirements of the law, but even if it can be shown that a particular individual isn't required to do those things in their day-to-day work. You say that's heterodox and not what you've agreed with the other side.
Well, that there's a line. There's a line which obviously must involve a particular exercise, as you said rightly, where the employer expects somebody to do something, and it may happen erratically. There's a line where they may expect someone to do it, and they don't perform because they're not doing it properly, and that's an issue for the employer. We're a long way from that in this case, because and that's why I'm sort of slightly hesitant about being drawn into those grey lines.
I don't want to raise red herrings, but I am conscious that this is a judgment in which the question of what is work may be looked at in other cases, where the issues are where it matters more than it probably matters here. And I just wanted to float these points to make sure that by simply accepting the formula that the parties have agreed, you only relatedly, but now that all the parties have agreed, we don't create problems in other cases by saying something too
Well, you can record that it's the subject of agreement, and if it's the subject of agreement, it's not binding on anyone else.
Yes, although I acknowledge that what's agreed between the parties is binding only between the parties in terms of agreement. But
anyway, your point about paragraphs 1 to 5 is that they show that the ET's just gone off the rails.
yes,
Because it said that the training documents are the key documents, and they explain why they say they don't agree with the parties' view about the training documents, and they don't agree with the way that the parties have prepared the cases. And the final point is that only if a claimant or comparator did any aspect of his or her job in a way which differed from the manner shown or stated in the training documents could there be a need to hear oral evidence on that aspect.
Yes. So we say they laid their ground for what we say is the disaster that follows. And although Mrs. Justice Stacey takes the benevolent conclusion that at all points the tribunal never lost its eye on those passages in Brynhofer, we say respectfully they never had their eye on it to begin with, let alone never lost their focus upon it. It's worth just looking at that little interchange about the agreed points that can I just take you to the core supplemental bundle briefly, and the core supplemental bundle, it's page 112. I'll get the tab for you. I'm grateful, thank you very much. It's tab 6. I take you to tab 112. That this is one of the emails from Employment Judge Hyam's 27th of October. In fact, it's an email replying to himself, because there's below it another email from him, also the 27th of October. I think a little earlier in the day.
Yes, it's not actually an email replying.
And it's the one below that's the important one, because it's saying thank you for your note, for that note, because what he's replying to is the email that you see on page
agreed note on the law.
Sorry?
He's replying to the agreed note on the law.
Yes.
Yeah.
And
He says his understanding is slightly different.
yes. And he makes it clear, we say, the approach that was previously indicated. There is a glimmer there, and I haven't really gone there because this was part of what the EAT recognised was an error of approach to a judgment in the Employment Appeal Tribunal of the then president.
This will shorten your task. I looked at that, but I could not see what the possible relevance of that case was to the issues that we have here. I'm bewildered. If you look at it. So you may want to rub it in, but I won't take any persuading.
I think you'll have a wry smile, but I think in a footnote in relation to that particular judgment.
All my best observations.
Sorry?
End note rather than
I apologise. It's an end note, not a
Footnote.
footnote.
It was a
I
footnote.
apologise.
Because the ICR won't do footnotes and shoves them all at the end. But the authentic judgment is a footnote, so you're right.
Sesquipedalian dispute.
There's a reference to a slightly broader view about the generic, because obviously that case was concerned about amendments and the problems of identifying individual comparators. And that's part of what the judge latched onto, the idea that one was looking for a generic finding. Now, it may be, your lordship raised a similar observation in relation to that earlier section, but ultimately all the parties were in agreement that this wasn't a case that assisted the court, it took it in the wrong place.
Yeah, well, I think so. Obviously I was concerned 20 years ago, whenever it was, not quite that long ago, with this problem of generic. So I suppose in that very general sense, it may have, but it's a very long way from any of the issues here.
Yes. Yeah. That, however, reflected the tribunal's approach, which it then, having, as I indicated that it was going to go on after that process to reconsider matters itself, took it to the substantive judgment, which is the focus of this appeal, the second judgment. And you find that in the core bundle. Core bundle, and that is tab 18. And I start at paragraph 9. 284 has a paragraph headed legal principles.
So what do you call this? The second judgment?
Yes, this is really the subject of our substantive appeal. This is
Yes.
the judgment which the tribunal produced in July 2024. And we say consistently adopting the same approach. You see it at paragraph 9. And we've particularly highlighted the passage in 9. The basic principle of all of this was this: an employee's job is not what the employee says it is, but what the employer says it is. The employer requires the employee to do the work, and the employer is required to do that work. And we see that coming
What's
down.
wrong with that?
Sorry,
What's wrong with that?
I'm so
Well-
sorry. Which paragraph? It's my fault. I was catching up.
That's true in contractual terms, but it's not the answer to this process.
What's wrong with that in equal value terms?
Well, it's really, I'm sorry, I do apologise to answer your question, it's paragraph 9.
No, sorry, it's my fault.
It's where he goes from that in terms of 9
Two,
to
I've got it now, thank
13. Bottom of 285. And 13.3, because instead of focusing on what's happening, the focus becomes on the requirement to do.
99% of cases, a distinction without difference. People do not do stuff at work which they're not required to do. Why would they?
That's true. But if you're focusing on the process of looking, it couples in with the training documentation, one's focusing on the process of only looking at what the expectation is of the requirements to do it, but actually not focusing on what individuals actually do. I agree that may be...
They were incredibly rare. You will obviously get exceptional cases where your contract requires you to do this, but in fact you do something quite different. But in the normal case, especially a highly managed job like this, people will do what their managers tell them to do, and
Yes.
it's only I suppose possibly it comes back to this question of extreme granularity, which I suppose the employer says you must always put the ice cream on top of the ice cubes, and they always put the ice cubes on top of the ice cream. Then you might say, well, then you must see what they actually do, but that's not likely to affect the evaluation anyway. So,
well, the difficulty in that exercise is obviously one can take a view as to whether or not it's likely to affect it or not affect it, but ultimately that evaluation exercise is going to be determined by the independent experts and others. So it may or may not. But just going back to your point, it's not just, obviously, I'm articulating this as an appeal on the behalf of the respondent, and therefore my focus becomes looking at specifically what we've said the comparators do, but the granularity is equally true of the claimants in terms of their process. Their job descriptions and the records of dispute recognised and adopted the same level of granularity that wasn't at the level of the generic concept of the requirement of the particular role. So the point I'm addressing is that this is just a continuation of what they said erroneously in that first judgment. And
Because the statute doesn't define the task by reference to the requirements of the contract of employment. What section 65 and 64 and 65 looking at are the demands of the work.
yes, it doesn't talk about the contractual obligations. Taking the point that the employer's expectations, the contract is the medium through which the employer has the work done for it,
Sure.
and therefore some contracts will typically include an X job description, but it still doesn't change the process of the particular work. And indeed, if you took the example of someone who'd been doing a job which contractually was job A, but over the years, the nature of that particular role had radically changed so that the work was actually totally different in terms of process. What the legislation is telling us is you look at the actual work.
Yeah, well, that's absolutely right. But of course, as I say, in reality, I mean, the demands of the job are the demands that the employer imposes on you. And normally, as you say, through the medium of the contract. Indeed, in practice, always through the medium of the contract, whether written down or not, because he has no other right to tell you what to do. So I can't really see what all this goes to. What problems these rather unwise departures from what the parties had agreed actually are likely to cause in practice, except on the training manual point.
Well, the training manual point,
which you're coming to later.
yes,
Obviously, if you say don't look at what they did, look only at what the training manual says they should do, then we're in problem, and that may well be your better point. But at the moment, just on this ground one, I can't see what substantial difference these nuances about how you express the what the work or the demands of the work consist of really make much difference.
well, what I'll do is I'll take you some examples.
Yes, that would be helpful.
Can I, before I leave those examples, just as a parting shot, at 3.10, it's in our skeleton argument. I don't need to take it any further. It cross-references paragraph 25 of this particular judgment, 290, because in looking at the law, the judge refers to Brunhofer, but misquotes it. He selectively quotes part of the judgment and doesn't refer specifically to 49, the passage I took you to, that focuses on the actual nature of the work. And this, we say, is consistent with his approach that somehow the law has been misstated and his approach is the correct one, as distinct from what the joint note of the parties said.
The first few paragraphs are where the employment judge distinguishes Shields, you say, on a
Distinguishes
Shields and Coons. Isn't there a reference to Shields and Coons?
the passage where he
13.
Yeah.
yes.
Well, he refers to some bits in 11 and 12, and then he says it's of very little relevance to us, at least in the majority of factual disputes, and then he explains why.
So that's where he effectively departs from the Shields approach.
Yeah.
And then at 25, it's on page 290. He refers to Brunhofer as being consistent with this approach. And that's a passage where it's actually an incomplete quotation from Brunhofer and doesn't include the passage at the end at paragraph 49, which I took you to, where the Court of Justice specifically articulated the need to look at what an individual actually does. So he's reinforcing his own erroneous approach to the law. Because just to note, below, Mrs. Justice Stacey accepted that these passages indicated that the judge had misdirected himself in relation to this process. What she concluded was, looking at the judgment as a whole, and this is what we find really not to be explained, that hadn't been lost sight of. But perhaps to answer your point, I'll just take you to some examples in relation to this exercise. Can I take you? So we have to look a little a little into the facts, can I take you in the core bundle? I'm going to take you to page 643, and you find that we're in the judgment. So it begins at tab 18 in the second judgment. I'm not sure
It's
whether
in
page-
volume 3, 643.
Helpful if this bundle does have page numbers on the back, which is very useful.
Which paragraph?
It's 643, and in the judgment, it's paragraph 172.
Of Appendix 7.
That's correct. So just so you know how the geography of the judgment works, Appendix 7 is their findings about one of the specific claimants, in this case, a Miss Garrard.
What was her job?
That's a very good question. I don't remember. I'm very grateful. By those who are on the front line, remind me that she was an express customer assistant. So you're familiar with the Tesco Express. I think there's one over the road in Fleet Street. She was a customer assistant in one of those stores. And and when you see references to documents such as C71452 to 17, that's a reference to the bundle of documents and specifically a training document. And C7 being the folder, I think there was a digital bundle at trial, 145 the document, and pages 2 to 17. And what you notice the tribunal are finding, similarly if to the extent the respondent opposed any part of paragraph 147, so paragraph 147 would have been the paragraph in the record of dispute where there was an issue between the parties, we conclude that the principles of C7 145 2 to 7 applied and therefore prevailed, irrespective of the evidence of the parties about what the job holder in fact did or did not do.
But I think this would be helpful to know actually what it's about. Is the heading is working on the checkouts. So is the issue whether or not she worked on the checkouts?
It'll be more specific than that. It'll be some aspect of what's involved. I'm not sure I can take you to the answer of that particular exercise.
No, I can obviously see why this is a very provocative way of putting it and supports your case. But as you know, my concern is actually how does this play into the actual decisions that the tribunal were making? So it'd be quite useful to know what paragraph 147 said.
Can I come back to you on that? While someone checks
in this case, you're all absolutely steeped in this, or those behind you even more than you, and we aren't. So just, if you're going to give specific examples, they need to be specific. Yeah.
Yes.
You're about to be told what paragraph 147
I'm
said.
good. 147. Give me a second. 147 was concerned with the packing of customers' shopping, included such things as opening and whether or not required to open and check eggs, bringing meat deals to customers' attention, offering alternatives when noticing customers had damaged goods. So it was about the.
I see. Okay.
So
Really what they're saying here is the fact that whenever a customer was buying eggs, you ought to have opened the thing to check whether any of them were cracked, which I have sometimes seen done, though not very often. Since that's what they're supposed to do, they're to be treated as doing that.
yes.
Even though the evidence apparently was we never did that.
Yes, and of course, you know, in terms of the exercise, one's looking at the particular individual working in that particular express. the effect, as you rightly say, is to say, we're looking at the training material. If the training material says that this is part of the role, that's what we will say will be the finding in relation to that particular exercise. When we come to training documents,
So just before you move away from that specific example, just to be sure I've understood this, if the training document says every time a customer at checkout presents a box of eggs, you have to open the box to check that none of them are cracked, but the individual job holders' evidence is we didn't do that, you say you should look at what they did in practice, and the tribunal has said you should look at what the manual says.
yes, so as you can see there, the tribunal is saying, regardless of what the evidence was, we're not looking at.
No, they're saying another part of the evidence is more relevant. It's not regardless of what the evidence was. They weren't denying that she said, I never did this in practice. They were saying what's more important is that it was part of your job to do it. And I imagine their thinking was, you're paid for what you're supposed to do, even if you don't always do it.
Yes, but again, going back slightly further, so I wouldn't quibble about it having an evidential value in looking at process, but actually their process is to say we are looking at the documents to define the work, as opposed to evidentially using it as a tool in this particular process, as they articulate there.
I hesitate to interrupt. This discussion seems to be proceeding on a false premise, which is that Ms. Garrod's statement said that she didn't check eggs. In fact, it said that she did. We can get you the relevant documents if
I
you
wouldn't
need.
All right, but in that case,
No,
in
that
that
was
case,
my lord's question. I don't think we misunderstood what's here, because we understand that the respondent's case, I think, was that she didn't.
No, well, I've not understood, I'm afraid, and I would find it helpful to understand a specific example of a mismatch between what you say the tribunal should be looking at, which is what the employee actually did, and what the tribunal is looking at, which is what your manuals say they ought to do. And I haven't quite now understood what the egg example is. I mean, or give us another example. I mean, but I think I've understood that your case is that ultimately what's important is what the employee actually did,
Yes.
regardless of what they were required to do by the training manual.
Yes.
And what the ET have not said is that we accept their evidence that she did it. They said we accepted that the JH was expected to do those things. I mean, do they go on then to say, and that's why we accept her evidence?
I'll be corrected if.
It would be
if I'm
one
wrong in
thing
stating
if
that,
they
but
said
I think
that
that
was her
is their
evidence.
conclusion. So
that was her evidence and it's backed up by the training manual, that would be one thing. But is that their process of reasoning?
I think their conclusion is what we see at that paragraph at 172, which has with it that issue that when it comes to working out their determination of fact, what they've included is 15 pages. I appreciate that will cover other issues, but they've included 15 pages of training material in that process of determination.
that is a separate issue. And an important one.
It's a very wide general statement at the beginning of 170. We concluded that the principles of the training manual have therefore prevailed, irrespective of the evidence of the parties about what JH in fact did or did not do.
That's why Mr. Bryant's intervention with respect wasn't terribly helpful, because it doesn't really matter whether actually she said, I did check the eggs. They were saying, we don't care whether she said she did. Even if she says, I don't check the eggs, all that matters is that she was expected to.
Yeah.
That's your point of principle.
Yes.
Yes.
Can I take you to another one where you can almost see the enclosed process and leaving you with what have they decided? Hopefully I'll try and make it clear if I haven't made it clear. Another example might help. Can I take you to page 402 in the judgment?
This must be a different judgment. No, it's the same judgment, sorry.
Same judgment.
It's different volume.
Maybe there's volume.
Oh, the different volume, yes.
So this is Appendix 2.
Yes. So this is Siobhan Williams. I'll have to double check. I'm grateful. Yes, so one of the things that she was also an express customer assistant.
Yep.
One of the things that made this case in retrospect slightly more troubling in terms of the amount of volume is that the claimants were able to nominate claimants, some of whom were doing the same job. So in some litigation where there are multiple representatives, there's been one claimant.
Yeah.
But here, the reason there were 7 in the end claimant roles.
I thought it was
6.
6.
Sorry, 6.
So
3 roles, 6
3 roles.
claimants.
3 roles. 6 people was that everything was doubled up.
I've in all that explanation, I've forgotten what page number you wanted.
Yeah, I'm sorry, it's 162. Oh, sorry, it's paragraph 162. It's page 402.
Thank you.
It's a paragraph, and this is about going into the freezer in the store's warehouse. So hopefully we can see the nature of the issue. The issue was whether or not she did go into the store warehouse freezer. Can I just invite you to read it? 162.
That's a bit of a muddle, isn't it? I mean,
So
halfway through they say we accepted the evidence that she didn't replenish frozen foods. Then the next paragraph says, but all the same, we thought it was important to record that it was part of her job to do so,
yes,
even though she never did it, which I understand is obviously the kind of debate we were having then. But then she says, we concluded that she did replenish frozen foods occasionally within the meaning of H31. What's H31?
one of the training documents. I'm sorry, apologies.
Well, that's...
Oh, okay. Sorry, apologies. My fault. So it's actually something which was how you recorded frequently. So occasionally. So in order to assist in evaluation, what typically happens is the IEs produce something to say how many. So there's an exactitude of language. They know that if somebody's described as something occasionally, what that will mean in terms of how frequent. So what they're doing is they're concluding that on the basis of that, occasionally meant over a period of several weeks or months. So, but you're right. The point I'm making here is that on the one hand, they're saying we accept the evidence of the respondents' witnesses that she did not in practice replenish frozen foods. And then at the same time, they appear to be concluding that it's a requirement of the job that she does so. And so it's very hard to understand how these things lie together unless one recognises that what they're doing is actually holding light anything about the evidence about actually what happened and focusing more on the exercise of descriptions in relation to the requirements of the job, in part through the training documentation.
You're in an impossible situation, though, aren't you? Suppose you have 100 claimants doing with the same job title, and just because of individual idiosyncrasies between different stores, or maybe within the same store, some do some rather demanding thing and some don't. Some of those claimants will have equal value claims and some won't. I mean, assuming that was the only factor. There's got to be an element of the generic requirements of the job, whether done or not, hasn't there? Otherwise, the whole situation becomes wholly unmanageable.
Well, what
happens with your sample claimants? No sample will be a representative sample, because if you go to this degree of granularity, the whole sampling exercise will become useless, because that's fine, but I'm afraid the lady in the next place did go into the I've chosen a bad example, but some factor that is in favour of her claim isn't present in how another individual did the job.
Well, that is, we say, a consequence of the way that this exercise works. And there's no direction, and the legislation is not constructed around the determination of a generic type of role. Now, I appreciate your reference to the Ashton-Colborne litigation. Obviously, that there is potentially a point if one raises arguments about whether or not a particular role is truly of equal value for a particular individual, to the extent to which that's arguable if in fact there's nothing radically different about that particular process. But when it comes to looking at what the evaluation exercise involves, it does mean looking at a particular individual. So it is important for this particular.
The samples are samples in the true sense, and they can never be test cases.
Sample is the correct word. I mean, it's hard to have in the structure of the legislation a true lead claimant, in the sense that their determination of their claim is reflective of the determination of everybody else.
Depends how narrowly you construe the idea of a claimant and their comparator doing the same work.
Yes.
If it means more something like doing the same job, or doing work of equal value or job of equal value, then that problem goes away.
Yes, although as it stands, looking at the work is in the way the legislation is constructed and has been consistently applied, the job is not the requirement in the sense of framing its description or its contractual terms. It is. Now that may get translated as what people do, but the process of the legislation is still to look at what people do.
So you say it's just inherent in having test claimants and effectively test comparators?
Yes. As I say, it may be that there's a problem in a comparison between Miss X, who makes a comparison with Mr. Y in a single case with one claim.
Professor Fredman describes it as myopic. A myopic focus on the individual comparison.
Well,
Wrong.
She may be right or she may be wrong, it doesn't matter. That's your point.
Yeah, it is where we are, and it does create a problem if instead of...
you may think I'm expressing a view. I'm not. I'm just
You're
trying to
testing.
understand the implications of what you're asking us to decide.
Yes.
Can I be sure I've understood it? As I understand it, your focus is on the work that an individual employee actually does, not what their job says they ought to do. And hence it follows that when you take a sample claimant, you're looking at that sample claimant, and it may be that's not precisely, they may not do precisely the same amount of work as another person in the same cohort, but that necessarily follows, because what you're doing is looking at the individual's work, not their job. You're not looking at a hypothetical express customer assistant in a hypothetical store. You're looking at a real customer assistant in a real store on what they actually do and how they do their job, not how they're required to do their job. Is that right? That's
correct. And that's the way the case is reflecting that.
I understand that. Can I ask you to look at 204, because there's a cross-reference in 162 to paragraph 204. And 204, this is the same, as I understand it, the same job holder. It's still Siobhan Williams. And they asked the same question. Did she replenish the foods? And how, if so, how did she do it? And they seem to accept the evidence that she did not in practice replenish frozen foods, but she could have been required to do so. So it was part of her job, but not part of the work she actually did.
Yes.
And then they go on and say, if she'd done it, she would have had to apply the merchandising plan. And you say that's all irrelevant because she didn't do it.
Yes. And just to pick up on the point about the management, you're exactly on the point I'm making. The way that the case was contemplated and case managed involved the individual claimants. So the individual claimants gave evidence about what they did.
Yeah.
So it's what they did. And having selected their comparators, there was, in fact, I think one comparator, Mr. Jones, who didn't give evidence because, of course, it's not part of the normal job description of an employer to compel
Can't make
people.
them give evidence, no.
So in some of these cases, the comparators do give evidence, others not. In where they don't, it's typically the managers. But again, the focus is on that particular individual.
This paragraph suggests that in relation to Miss Williams, you called evidence, presumably from managers in her store, to say she never went into the freezer.
Which they appear to accept. But
yes,
then
which they accept that. But they still say it's part of her job.
Yes.
And that, you say, is the error. Because it wasn't a question of whether it's part of her job, it's a question of whether it was part of the work she did.
That's exactly right. And what we see is that example reflecting the erroneous earlier approach. Now, taking the observation, that is a problem that underlines the entirety of their approach in relation to this particular exercise. And points will be made about reconsideration and looking back at them addressing things. But what we see is, quite consistently, perhaps not surprisingly, the tribunal having articulated their view that they were going to take a particular approach and then doing it. And where we say that Mrs. Justice Stacey went wrong was not in recognising that there was an erroneous, some erroneous observations about the law, but actually recognising the fact that that then gets carried through consistently in the way that they approach. And that means that the totality of this exercise becomes problematic.
Well, speaking for myself, I found that freezer example with Siobhan Williams much more accessible than the slightly murky egg example, where I'm not quite sure what the facts are. And as always, I find these sort of points much easier to grasp with concrete, practical examples, which I can get my head around. So I'm not going to tell you how to do it, but if you had another sort of example along the same lines.
Yes, I was going to take you to an example which is, it doubles up. It's a slightly longer passage, I confess, but it doubles up because it shows the tribunal not accepting something which in fact had been agreed between the parties and focusing on training documents. And on reconsideration, they're compelled to change their mind, although still dealing with the training documents. And that concerns Mr. Jones. And we need to go in the judgment to page 737. I think we're back to volume 3.
So he's one of your comparators.
He's one of ours, and he's an assembler.
He's actually the lead one, isn't he?
Sorry?
The anchor comparator.
He's the anchor, that's correct. And this is concerned with...
Sorry, this is actually a different appendix, but it's still about him, is it?
It's still about, it's Appendix 8, it should be.
Yes.
Yeah.
Well, it wasn't the previous example in Appendix 7.
Was it? I thought it might have been 8. But, well, Appendix 7 would have been the previous example because that was a different... that was a claimant. So...
Oh, sorry, my fault. Okay, anyway, so, yes, I misunderstood. Yep, okay.
So this is concerned with...
B7, did you say?
Yes, changing the battery of a lollop. That's a low-level order picker. So it's a piece of equipment used in the warehouse that had a rechargeable battery. I've taken you to the passage, and knowing that you've got a hard copy, could I also ask you, just so you can understand the context of this, if you look at the supplemental bundle, and if you look at page 914, I'll get you the paragraph with that. That is in
That's volume 3.
volume 3. It should be tab 56. What I've done is I've just taken you to this. So these are, as we looked at an example of it before, extracts from our closing submissions. And you can see that there's a subheading called battery changing. And you can see beneath it there are elements broken down about changing the battery. And if you look at 6.235, as part of processes changing the battery, or checking the battery, or sorry, changing the lollop, it refers to the fact that the employee, Mr. Jones, might have to manually manoeuvre the filled cages. You can see that it talks
What
about.
is a cage?
I'm sorry, it's on page 915.
What is a cage?
I'm sorry?
What is a cage?
Oh, a cage. The cage is what the stock was packed into. So
I see. So this is not to do with battery changing.
well, the battery. So this is part of the process of changing the battery of the loader. That in order to change that, you didn't change the battery physically, you changed the loader, and that meant that you had to, if you had to change the battery part way through your work, you had to take the cages off, swap the loader, and then reload. And in 6.235, there's reference to Mr. Jones having to physically tilt the carriage. I know, my lord, you've got an eye on the clock.
I think this is going to be a longer example than. Can you find a convenient moment?
Yes. I'm going to take you back to the paragraph. Just, I'll give you the short point before I'll probably pick it up briefly at 2 o'clock. But by the time that we got to the end of closing submissions, that paragraph had been agreed. But when I take you back and you look at the passage that I took you to in the judgment, and it's actually between paragraphs 283 and 294, what the tribunal does is that they conclude that having looked at the training materials, what's been agreed can't be right, and there's no need to physically tilt the particular carriage, even though that had been the evidence, and even though it had been agreed between the parties. So that was the evidence of exactly what had happened. Now, I'll pause, but obviously you can see that the physical manoeuvring of the loaded cage may have more impact in relation to value than not having to do it. But it's their focus on the training materials. Just for your reference, it runs through that part of the judgment where you can see them doing that is from paragraphs 283 of the judgment through to 294. And 294 is the critical point because, in fact, having rejected the evidence, which by then was agreed, they actually use it as a reason to doubt the veracity of the respondent's evidence. I'll pause there.
2 o'clock.
All rise if able.